Started now. So, very good afternoon to you all. Thank you for joining our webinar, My First Mediation. My name is Phil Hesketh. I'm a mediator, former personal injury lawyer and director at First Mediation. And I'm joined today by two highly experienced mediation colleagues, Brian Dawson, solicitor and deputy district judge and very experienced mediator, and my colleague Paul Balin, also a highly experienced clinical negligence litigator and mediator. Welcome to you two, and apologies for any of you who joined hoping to see Mira Lachani, who we had advertised was going to be presenting today, but unfortunately Mira is unable to join us, so thank you, Paul, for stepping in. As I said, the webinar is being recorded. We're very happy to take your questions throughout the webinar. You'll see there's a Q&A button. You can fire your questions in there, and we'll try and deal with as many as we can. If we don't get around to it, then we'll get back to you offline. And also, if there are any questions after the mediation, please ping one of us a message, and we'll be very happy to get back to you. Our webinar today is primarily aimed at people who perhaps haven't been to a mediation before, or it's been a long time and they would like a refresher. And it's broadly for clinical negligence and personal injury, although there may be some other people attending from different practice backgrounds, but a lot of what we'll say will be relevant to that as well, hopefully. If you haven't done a mediation before, and it may be because you don't think personal injury or clinical negligence mediation is necessarily relevant to you, just to let you know that we've worked with over 200 firms, different firms, and we've done on the NHS resolution mediation scheme alone something like 1,300 different mediations. So we work with literally thousands of litigators. So you're not the first person to try this out, and you're in good company. So much so that there's a debate as to whether or not we should be dropping the word alternative from ADR, but I'll leave that discussion for another time. But you're all very welcome. We're hoping to give you an overview of what you can expect from a typical mediation, or at least typical that any of the three of us might run. So that you would have some confidence in knowing what to expect on the day. And we'll also give you some tips for how to make your mediations successful. Happy to report that of those cases that I've referred you to, the settlement rate, by which I mean the cases that settle on the mediation day itself or within 3 or 4 weeks afterwards, it runs between 70 and 80%. So it's a relatively high settlement rate. So you can take some confidence in the fact that there's a purpose to what we do. Also, I'd like to just give you, if I may, a bit of up-to-date background, in the sense that reasons why you might wish to look into mediation a little bit more than you have perhaps previously. One of those is the Court of Appeal decision at the end of last year, which is Churchill and Merthyr Tydfil Borough Council, in which we've covered in more detail on a previous webinar, but just very briefly, the court decided or ruled, the Court of Appeal ruled that the courts and their practice management can order different forms of ADR, including mediation. And so important was that decision that earlier this year you probably saw that the Rules Committee put out a consultation for some changes to the rules. And I apologise, I hope you bear with me, but I'm just going to give you a little flavour of some of those changes, which I'm afraid means me reading one or two of the passages from the CPR. But these are fundamentally important, and so I'm just going to do that. The first one, Part 1.1, that's the overriding objective, so it doesn't get much more fundamental. And as you know, the overriding objective at the moment states that dealing with a case justly and proportionate costs includes, so far as practicable, and this is the bit that is proposed to be added, using and promoting alternative dispute resolution. So that's the first part. Part one, other changes, part 1.4, the court's duty to manage cases. Active case management includes encouraging, and now they're proposing to add, or ordering the parties to use an alternative dispute resolution. So that's, we're going from beyond encouragement to ordering. Part 3.1, the court's general powers of management, except where these rules provide otherwise, the court may, and the new part that proposed is order the parties to participate in alternative dispute resolution. Part 28 is about directions, the matters to be dealt with by directions under Rule 28.21 include, and the new part will be, whether to order or encourage the parties to participate in alternative dispute resolution. Case management 29.2, the new part is proposed to say, when giving directions, the court must consider whether to order or encourage the parties to participate in alternative dispute resolution. And finally, part that we all worry about, the part 44, court's discretion as to costs. It already says that in deciding what order, if any, to make about costs, the court will have regard to all the circumstances, including the conduct of all the parties. The conduct of all the parties includes, and the new part will be, whether a party failed to comply with an order for an alternative dispute resolution or unreasonably failed to participate in alternative dispute resolution proposed by another party. So thanks for bearing with me through that, but I think you'll agree the importance of these proposed changes is really significant. Now, I think there's a ballot or something going on around the country tomorrow which may influence the date of whether or not these changes come into force and when they come into force. And it's impossible to predict what will happen if they do, in fact, come into force. But there's a reasonable assumption that it may mean more mediation. And for you, that may be a good thing or a bad thing. And we're not here to comment on that. What we are here to do is to reassure you that we have a solution if it's a problem for you. And the solution is that we can tell you, we can help you understand what mediation is, how you can benefit from it, and how you can make the most of it. And we can assist you, as I say, with questions about that offline after this webinar, if you have any further questions. So, without any further ado, after all that ado, Paul, could I ask you, what might be the first steps to take if you're thinking about mediating a case?
Yes, and I'd ask the question as well, is when would I be thinking about mediating? And I would say any time in the life cycle of your claim. And Phil's just quoted you some settlement statistics. Our analysis shows that those statistics don't alter, no matter where in the litigation cycle you choose to mediate. So common sense suggests that the earlier you choose to mediate, the better for your clients, the better for costs, and it's a win-win situation. So don't be frightened to consider mediation at a pretty early stage in your process. Certainly, I would have thought, bearing in mind the changes in the rules that Phil has mentioned, certainly by the time you're looking at the stock take at the towards the end of the pre-action process. Are any particular cases more suitable than others for mediation? Well, we would say all cases can be mediated. We're here to help parties resolve the cases, but there are some things you might be looking out for. For example, in a clinical negligence case, if your client is looking for something more than what a judge could order in court, we call those extrajudicial remedies, and we'll no doubt discuss those a bit later. Or where you might want some help dealing with a particularly difficult opponent, or you simply want to take the heat out of the matter, maybe in a particularly sensitive case, and see the strengths of proposing a resolution process in a much more relaxed environment than the usual adversarial debate between opposing solicitors. So those are just some suggestions when you might be looking for mediation. What about looking for a mediator? Well, obviously, we hope you will approach trust mediation. It's my current role to deal with enquiries. And if you haven't uh, participated in a mediation before or set up a mediation before, don't be frightened to contact us through registrar@trustmediation.org.uk, and we'll literally hold your hand. There's no embarrassment in disclosing this is your first mediation, and we'll explain the process to you. But basically, propose mediation to your opponent. You've got the strength of the judges and the rules now behind you in doing so. And you can approach us at Trust Mediation either to nominate mediators with their CVs for you to look at and agree with your opponent who you might wish to run the mediation for you. Or you can simply say to us, we've agreed that we're going to mediate on a specific date or within a particular period. Who have you got available? If it's an NHS clinical negligence case, then our mediators on the NHS resolution panel are pre-approved by NHS resolution, and therefore effectively the choice of the mediator is that of the claimant solicitor. In personal injury cases and clinical negligence cases outside the scheme, then the choice of mediators has to be by express agreement, and we can supply CVs of appropriate mediators. We can indicate which are more senior mediators if you're dealing with a very high value case, and you can also look up our mediators on our website. In dealing with your inquiry, it's useful for me to try and help you if you let me know roughly the amount in issue, the value in issue, because obviously I wouldn't suggest or provide you with details of, for example, a King's Counsel to deal with a particularly small value case. We have mediators who are solicitors, junior counsel, senior counsel, experienced solicitors, solicitors with slightly less experience than the greybeards you've got on this screen. And we obviously have a cross-section of the community for you to choose from. It's useful for us to know, therefore, is it a clinical negligence case or a personal injury case with or outside the NHS scheme? And also, if you have reached agreement at this stage, whether it's going to be in person or online, we'll try and reduce people's travel if it's going to be face-to-face by nominating some of our mediators perhaps nearer the proposed venue. And once you've agreed a mediator and a date, I then hand over to my colleague Phil, who you've already heard from, who will circulate the mediation documents. And for that purpose, it's useful at a very early stage to know if there are anybody going to attend the mediation who's not a representative of a party, for example, relatives or simply a supporter, because there's an additional confidentiality document that will have to be signed by that person, because a party solicitor will not be instructed, therefore not able to sign for them. So with Phil administering the mediation and sending out the documentation, you will also receive an introductory email from your chosen mediator. And I'll hand over to Brian now to explain how the mediator will be able to guide you through your first mediation.
Thank you very much, Paul. And I note that Phil is actually the only person with a grey beard in this.
And in this light, it's more white than grey, but never mind.
Keep that out. I should mention also that this is these from now. It's going to be a sort of fairly interactive session with the three of us, hoping we'll all chip in because we've all got our own separate experiences, of course. So if you hear one of the other two chipping in and speaking over me, they're not being rude. It's just this was agreed in advance. The other thing I should mention, if for those who it genuinely is a first mediation, that the fundamental rules are, of course, that whilst we may be pre-approved by NHS resolution, we are utterly impartial, and I think that's a point worth mentioning. And the other thing that's worth mentioning, because I'm going to come on to pre-mediation discussion, is that anything you say to a mediator in private is in confidence. And that is something that I personally don't think you can stress too much, because I think it's vital that you must be confident that whatever you say to the mediator is going to stay with them and not go any further, not least because my approach, and I think the approach of my colleague, is that if we can persuade people to work with us and trust us when we say that, then the whole thing works more quickly and better. So the first contact you're probably going to have, apart from an initial email, is when you have your initial telephone call or indeed webinar call with the mediator. When would that be? Well, my approach, and I think that of my colleagues, is to really have it as early as possible, but certainly early enough so that we can establish whether there's any, for example, any information that or any documentation that one party is waiting for, the lack of which might impact on the chances of resolution. I mean, I often hear from people that when I get on to talking about the case, well, they're awaiting a schedule from one party or the other, or an expert report, and of course, early involvement means that we can, with permission from both parties, help chase that sort of document up. So fairly early on. Why? Well, several reasons really. And I've touched on one, which is to see if there's any outstanding documentation we can help with. But really, so we can firstly say that we can meet the lawyers and often the clients. I find it really helpful if I can speak to, or even have a word with the clients direct, and that's both parties, but particularly the claimant, in advance, because it helps reassure them, and particularly when we tell them that they're not going to be asked to go outside their comfort zone, which is often a huge relief to people. And building rapport, I don't think, can be underestimated. Like anyone else you're working with, whether it's a barrister working with a lawyer, or a lawyer working with a client, I think building a rapport so that you can work together is extremely important. To digress a little bit, when I first started doing this in about 1996, when time was not as quite such a rare commodity as it is now, they used to reckon you should try and get to know the parties, go for a coffee with them, go for a drink with them. By the time you're leaning on each other at 1 o'clock in the morning saying you're the only friend I've got in the world, then they reckon that you could probably trust each other. But we don't have that time, but we can at least phone you in advance and get to know you a bit. Also, again, identify whether you have everything you need, and explain the process, and assist where necessary to prepare for the day. So what would that mean discussing? Well, first of all, the process itself and the trust mediation approach, which means not, unlike some people, not actually doing telling you what to do. Paul, I know this is a particular subject of yours. Do you want to chip in at this point?
Yeah, well, there's two things I'd like to say. First of all, a common question that I'm asked when I send my email and say, can I speak to you on such and such a date, is, oh, well, we won't be ready then. We won't be able to send you the bundle or whatever. That's not the purpose of the call, to discuss the case in that kind of detail. It's to create the relationship, as Brian said, and that's really important. But the other thing to emphasize is that mediators are a cross between your servant and a mad diplomat. And we don't come with any structural baggage. So there isn't a green book or a white book of mediation that tells you, at 10 o'clock in the morning, you will all meet and you will have 10 minutes to set out your position and this position and that. That's not how we, certainly at Trust Mediation, mediate. It's an informal setting, and it's our job as mediators to inquire gently of each party how they see the case being resolved and how we can help them. And we will then endeavour to structure our day to meet your requirements. Has to be both sides' requirements, because we aren't umpires, we're not judges, we're not arbitrators. We can only do things by agreement. And as Brian will explain, he will encourage the parties, hopefully to meet, but that's not a prerequisite. Over to you, Brian.
No, thank you very much indeed. Well, one of the things you would be talking about at that initial call, or at least touching upon, is how the day is going to go and whether you're going to have a joint meeting between the parties or not. But before we get to that stage, I think it's really helpful that you get to know the lawyers concerned, you get to know what their approach is, and talk through, particularly to people who haven't mediated before, how they're going to prepare for the day, and for example, has there been a conference with the client? Is counsel going to be there or not? Who's going to be in attendance? Is counsel going to be there or not? If counsel is there, has there been a conference? Has the whole case, has a risk assessment been carried out, and has the case been explained to the client, and has the client been taken through what any realistic parameters for resolution are? I won't say it's for settlement because it's not always just a simple, straightforward negotiation. But
Right, Brian, can I interrupt that? Can't that just be done on the day? You get to the mediation, have a discussion with counsel at the start of the mediation in a private room.
Well, you can have a discussion with the private room, but I think if at that stage the client is meeting counsel for the first time, and at that stage you discover that the client has just heard for the first time that maybe, for example, they've got this massive schedule they've seen and the money they expect to get out of this, that they might actually not succeed, and if they do succeed, they might not get all that they've expected. This can, in my experience, be frustrating for the other side, but also very difficult for the client, because that sort of advice, that sort of discussion involves a grieving process, and it's very difficult for the client to then immediately move on and say, oh yeah, okay, now you've told me that, I'll accept half of what I was expecting to have when I arrived this morning. So my view is it's quite important to touch on those issues in the initial phone call, just to see what the position is, what the client's expectation is, what the lawyer's relationship is with the client, and sometimes how we can help with that, and working with the lawyers to assist the client. Even in my case, sometimes, because I sit as a deputy, it's quite helpful for the lawyer to, if they want, to turn to me and say, well, what do you think, Brian? And I'm able to then say, I agree with everything your lawyer has said. So having those discussions in advance as to what, as Paul said, how we can help, what we expect from them, but also what they would expect from or like from us, I think is really important. The other thing, obviously, is to deal with any non-judicial issues that Paul mentioned. What is it something the client would like? Sometimes you find out that the client actually would love to tell the other side how what's happened to them has affected them. All of us have had that. Sometimes the client may not want to or may not be able to make their mind up, but it's often important to find out in advance whether the client wants to talk to the other side. And I say this from a claimant point of view mostly, obviously. I'm very well aware, as we all are, that there's a clinician on one side and a client on the other. But in terms of an impact statement, as it were, it is often helpful to know if the client wants something, whether the client is expecting an apology, whether an apology has been given already, and if not, what the client might be expecting. As I said,
Brian, I'm going to add to my mad diplomat and servant a choreographer now, because that's the precise area where we can add tremendous benefit. Because don't assume just because you're turning up to an informal mediation when you're acting for a claimant, and you then tell the mediator, say on the day, what the client really wants to know is, what's happened since the inquiry report, what have they done about that, that there will be necessarily someone there in the trust room, for example, that will be able to deal with it. So if that could be drawn out in this pre-mediation call, then either the mediator you're talking to will encourage you to contact your opponent and say, by the way, at the mediation, could we deal with this matter? Or you could ask the mediator in his or her pre-mediation call with the opponent to explain that they've discussed this particular aspect and have been released from confidentiality to do so, warn you that the claimant would really appreciate an update on what's happened since, what's done about it, so that no other patients suffer in the same way. Can they field someone who's got that information? And it's always better that that's planned in advance, so that the lawyers representing the trust are hopefully able to get the right person at the right time to deal with that with the depth of knowledge that a claimant will expect. And that's a realistic step for you to discuss at the pre-mediation call.
Yeah, thank you. And moving on from that, the other thing, of course, turning more of the emphasis on the defendant, perhaps more than the claimant, is this question of what authority will there be is there likely to be on the day? And I know defendants have got this all in hand, but it helps for the mediator to know, what the line of authority is, who hopefully is attending the mediation for the defendant, but what do they have any limit of authority? And if so, by what process will the representative be able to get more authority if the mediation, as you would hope, goes in a direction that means that there's reason for them to obtain further instructions and or further authority. So that's something that's, again, vital to talk about in advance rather than on the day when the whatever communication there is already in place, and so it's a little too late.
And I think, Brian, that goes with the impact statement that you mentioned as well, because whilst you said it's obviously something that would be important to the claimant personally and hopefully the claimant solicitor, but don't, if you're a claimant solicitor, underestimate the importance of that for a defendant in evaluating the case, in evaluating risk. And if you can persuade your client to give an impact statement, all of us will have experienced times where we've looked at each other, because we're much in the same position as the defendant, in that we pick up the papers, we read the papers, but all we get is papers, where what is presented when a claimant actually speaks and humanizes the whole process sometimes makes the impression we get from the papers totally wrong. And I've certainly experienced and seen defendants experience circumstances where what a claimant has explained is so far removed from what I envisaged, having read the papers, and they clearly envisaged, that it's changed the whole course of the mediation and potentially required them to seek more authority than they'd envisaged beforehand.
Well, you're quite right, Paul. And I think we're coming on to what happens on the day later, so I don't want to go into that too much. But again, the involvement of and the presence of the claimant can make a huge difference to instructions. I can remember briefly one mediation where I found out that the defendants had been tipped off. I say the defendant, I'm sorry to use that expression, but they'd been tipped off that it was all it was effectively all a con. That the claimant was trying it on and had boasted about that in the pub, and so that was actually resolved by the claimant with their lawyer's permission, saying, right, I'll go in there and I'll answer any questions you like. And so this claimant limped into the room, and I mean that, and answered whatever questions were put to him. At the end of which, it was quite clear that he'd made an enemy in the pub and that he was a perfectly genuine claimant. So as I said, I don't trespass too much on that territory, but Paul, you're quite right when you say that there are things that come out of the mediation, a bit like a court case, things that come out which can make a huge difference to the approach of the parties to that mediation. So as well as all that, and there are some practical things, obviously, we do to discuss how people are going to be preparing. So, for example, discussion about mediation bundles, what a bundle is and what it is not. I'll say briefly that a mediation bundle is not a court bundle. A mediation bundle is the documents that we need to assist the parties to resolve the issues in the case. That's very different from a court bundle where you throw everything in, and also the discussion of position statements. Phil, I know this is a thing you've actually given full-length webinars on in the past, and I just wonder if you want to chip in at the
Sure, and on position statements, we've got a document which I'll probably send out to people who've registered for this webinar so that you get some more information about it. A position statement is first of all, it's optional, okay? And Paul was saying there isn't a white book or a green book about what you must or mustn't do at a mediation. But one of the things that you can do is to send the other side and the mediator a position statement. And that's a document. You may exchange it, agree to exchange at the same time, or you may send it independently. It's up to you. But it's the start of the process for you to set the tone of what you're hoping to achieve on the day. What most people are hoping to achieve at a mediation is a resolution of the case. And this is the time to start that process. And you can set out what it's not a time to put a skeleton argument and explain to the other side why their case is hopeless and you're bound to win. That's not what a position statement is for. It's an opportunity to say how you see progress being made, what your client is hoping to achieve, if necessary, making some concessions about the case so that those things can be set aside for the purposes of the mediation. Concessions within the mediation, they can be set aside, and you can talk about what really matters. And the important thing about that document is to think about the audience that are going to see it. It's not just for the mediator, but it's for the other side and for the decision makers in particular on the other side. So the defendants would hope that the claimant will actually read this document, and likewise the claimant team will hope that whoever the decision maker is on the defendant side will get to see that document. So we do encourage it. As I say, there's more information. I'll send a document out about that, but we do encourage it. But if you don't choose to do it, that's a matter for you.
Thanks, Paul. Did you want to mention anything more on?
Yeah, I just wanted to mention the bundle because it's something that I'm really keen on explaining. The mediation bundle, as you said, is not the trial bundle, nor are they necessary documents that have reached what you might term court standard. If you, ferreting around your electronic files, have information that could help your opponent better understand your position, even though they're not prepared to trial standard. It could be an attendance note. It could be a draft of this or a draft of that. It could be a comment by an expert in an email, having read your opponent's expert's report. Just consider whether any of that information might help your client's case. I remember I got parachuted into my old firm as a case where the fee earner hadn't done a mediation before and asked me if I'd be the mediation advocate. So I came in as mediation advocate with another mediator there doing the mediation. And the defense solicitor turned up with counsel, and counsel was someone I've previously instructed in other cases. And he took one look at me. First of all, he said, "What are you doing there?" And I explained. And then he said, "Paul, why have you put an attendance note of your client's conference with counsel and expert in the bundle?" And I said, "Well, because we have got a very strong case. My client's counsel, quite rightly in conference, effectively cross-examined our expert. And here's a detailed attendance note. And I thought you'd like to see it. It's without prejudice for the purposes of the mediation. It's confidential. I've discussed it with my client, and it certainly helps his case. And I hope you understand, having read it, that our case is extremely strong." And he went away and thought no more of it. The case settled. So I imagine that it did influence them. But that might be an extreme example. But day after day, I have conversations with lawyers, particularly claimants' lawyers, who are sitting on information they reveal that they have. And I said, "Well, have you told your opponent?" No, because we've not reached that stage, or we haven't had the directions for exchange yet,
or it's not
we're
in a
keeping
form
up our
that's ready.
sleeve. Yeah.
Yeah.
You know, we're going to use it in court. Well, why are you mediating if you're just heading for court? This is your chance to resolve the case for your client. Give your client the choice. Does the client want the best chance of resolving the case today in mediation, or 3 years' time in an adversarial situation in court? I know what the client's going to say.
Yeah, and you often hear this, don't you? And we've all done this in practice. We've done this work in practice. Someone saying, "Oh, we don't want to disclose that yet," as you say, because you know, it might need to change it before trial. It's not in the right format. But we all know that if you do go on to trial, and as you say, 80% of these will settle on the day or very soon afterwards. But if you go on to trial, we know cases morph. But nobody can cross-examine the person concerned and say, well, on the mediation, the document that was, you know, was disclosed and then withdrawn. I can't say, well, in that you said something slightly different, because it's without prejudice and it's confidential, and the document will then have been taken back. So, I mean, I'm of course will respect those who are clever than me and doing this for a living, but I would just raise that as a, be cautious about saying, oh, I can't disclose that, or think very carefully as to whether actually you can, on a confidential without prejudice basis, disclose something that's really going to assist.
Brian, I'm just looking at the time. Are we?
Two very quick things. Approach on the day I discussed, because just make sure we're the same wavelength. When I say to clients themselves, well, you know, your lawyer's very highly trained to win, but today they're going to be stepping back and advising you of the strengths and weaknesses of the case, etc., because they want you to make a decision on informed consent. I need to know that lawyers actually buy into that in advance, and they have the good manners to mention it to them beforehand. But lastly, I would go through how the online system works and any issues such as, you know, I haven't got a door to knock on, can I just crash in, or do I need to telephone, and maybe have a practice session including the client. That's all I really wanted to say extra about that very important initial conversation.
Thanks, Brian. And we have deliberately spent quite a bit of time on that, because, you know, you've not even got to the mediation yet, but we think you have, because we think the mediation starts then, you know, so we deliberately spent time talking about that. Okay, so when we get to the mediation, whether that's in person or online, like Zoom or whatever it is you're using, what happens? Well, typically, you'll start in your private room. Each side will have a private room, whether it's a virtual room or a physical room, if we're in person. And the mediator will go from room to room. The mediator will start, or I would always start with a discussion privately with each room separately. And whoever's ready for me first, I'll go and talk to them. I will tell particularly lay clients who are attending, explain to them, you know, no doubt it's already been explained, but repeat to them the importance of the confidential nature of the discussion. So in your private room, whatever you say to me, I might jot my notes down, but I'm not going off to the other room to blurt it all out and tell them what you've said. And it works the other way. What I hear in the other room, I don't come into your room and tell you what's been said, not without express permission to do so. And I'll tell people that I might ask for permission, because I might think it's useful if we can pass something on. But if you say no, then it doesn't go. So that's a really important thing that I stress. And then particularly for lay clients coming to the second or third private meeting, or I might be repeating it, so just to remind them about that. And I explain it's confident, it's without prejudice as well. I won't go into detail now, but obviously that's part of the process. I'll check with the parties that has anything changed since that pre-mediation discussion that we've had, and we've gone through a lot of details. Has anything changed since then? Has there been any further disclosure or any other questions? Maybe the parties had planned to have a joint session and now they've changed their minds. So it's just checking over things like that. Remind particularly claimants to relax. Often they're not relaxed, often they're anxious. And hopefully if I've met them on a pre-mediation call, some of that anxiety will have gone, because I'll have told them these things. But I'll remind them it's their day, and any recommendations I may make as the mediator about the process of what we're going to do are simply that, they're recommendations, and it's for each party to decide if they wish to follow those recommendations, and the parties make the decision. Can't stress this enough. I'm a lawyer, I've read the papers, I might have my own opinion. My opinion will be imperfect, I've not seen all the evidence, I won't see any of it cross-examined. I'm not there to give legal advice. What I'm there to do is to work with each side to see if there's a resolution that both sides can accept. And there won't be a resolution unless each side agrees to that, and they're the people that make the decision. Okay. So that's the initial session. In that session, I'll check with each side, are we having a joint session at the start of the process? Are we all going to get together in the same virtual or physical room? And that may be simply just to say hello and see who's on the other side and introduce ourselves, and we may then break. It might be as simple as that. One thing I will say is I will never force anybody into such a meeting. If one person or party doesn't wish to attend that meeting, then of course we respect that. And sometimes people don't wish to, and we understand that. If we are having a joint session, it may be that the injured side may wish to make an impact statement, may wish to read it out, or have the lawyers read it out, as we've discussed earlier. It may be that there are discussions on technical issues. It may be, for example, that the defendant doesn't understand quite what the work history after the incident has been, and can that be explained more. And it may be that we've decided that we'll deal with that, and it's better to come from the claimant's mouth, and everybody's agreed, in which case we'll go ahead and do that. It may be that we're only the lawyers at our meeting, or the lawyers meet after the initial meeting and the lay clients have left. And then the lawyers may have a more detailed discussion. And again, in my practice is always to tee up in advance, not exactly get a strict agenda, but each party knows what we're going to be talking about. And it may be we're talking about the accommodation claim, because that's the sticking point. So we'll go into detail about that, and each side can deal with that. And these meetings can break at any point. Okay. Again, no strict rules. If questions are asked and you're not ready to answer them, we can break, look into the detailed answer, and come back with the answer again into a private meeting or through the mediator. No strict formula for how we do that. The opening session may deal with apologies or explanations if they're relevant, not often relevant in personal injury cases, more so in clinical negligence cases. You know, the drive for that may have come from the defendant's side. And it's a question of timing. Usually I would find those things are dealt with better earlier in the day. Sometimes we get asked, oh, let's just sort the claim out first and then we'll deal with all that extra stuff. But I think, no, it really helps to set the tone, and it can be hugely beneficial to deal with those things because they are important to people, and we can deal with them earlier on.
And if for any reason you do decide you want those dealt with at the end, it never happens, because I can tell you by the end of the mediation, certainly the claimant does not want any more involvement, whether or not the claim has been successful, other than perhaps to say goodbye. As Phil said, critical to have it on first if you have extrajudicial matters, and it really does set the scene.
Can I chip in there as well, because I think this is important. That I had one where I can't give details, but it was one where there had been quite a history, and it was quite a there was a person who was very upset because their wife died, and he felt there was several chances to save her, and he had risk assessment for the nuclear industry was what he did for a living, and he really wanted to talk to the other side about that. And to their eternal credit, the defendants agreed that they would. That issue was dealt with at the start. Arrangements were made for him to speak to the chief executive of that particular trust, and he then just effectively was extremely easygoing, if I can put it that way, in what he was agreeing, because that was his key issue, not so much the finance. And so after that issue was dealt with, the mediation resolved very quickly afterwards, and it's just an example of what Paul's saying.
Thanks, Brian. Okay, so we've had a private session. We've had in each room. We had a joint session. We may then have another private session. And at any point, we can convene a meeting of all the parties, just the lawyers, the lawyer with the mediator and the client not present. Sometimes we can do any of those at any point. Okay, at some point, hopefully, we get down to people exchanging offers. Because most of these are money claims, and so offers need to be made. And it may be that there are issues about who's going to go first. Well, we can help with that. We can help with those discussions, and I will always tee those up in advance in the pre-mediation call. Are you planning to go first? Are you waiting to hear from the other side? So that we don't spend 2 hours on the day deciding who's going to go first.
And just going back to that, Phil, that's an important point. In the pre-mediation call, do let us know if there have been pre-mediation offers, because I've done mediations where I've not been told that, and then we have discussions and debates who goes first and things like that, whereas you don't need any of that if you're fully in the picture. Same with if there's been interim payments,
Sure.
come along armed with that information, or tell
Yeah.
the mediator beforehand, so there is no confusion.
And another reason why I, as mediator, want to know what the negotiation history is because if, let's say, the claimant's last offer was £1 million, and then the opening offer they want to make on the day is £1.2 million, that's going to cause a problem in the other room. And it may be the other way if the defendants wanted to make a lower offer than their pre-mediation offer. Then that's got the potential to derail the whole process. So I want to know that that's what we're dealing with, and I will explore that in the room before that offer is delivered to the other side. So that's one of the key factors. And any offer that parties we discuss with me, I will explore, because most offers carry a message, whether it's explicit or it's implicit, and I want parties to understand what message, or to be clear what message they're passing on. So I will investigate that, and I'll often ask, a party, how do you think that offer will go down in the other room? And then if they then say to me it will go down terribly, I'll say, well, is that helping us with the process of how we're going to try and do what you've said you want to do today, which is to resolve this claim. The early offers, my practice is to encourage parties to deliver them in person in the same room, because they can answer any immediate questions. You can see the reaction of the other side to your offers. Later on in the day, when we've done all of the talking and there's very little extra commentary to go, then I usually go room to room. But other mediators may vary with that.
Well, there's no rules in all this, but information is key. So, for example, if you have struggled with your opponent, or if your counsel has struggled with the opponent, either in this case or in the past, share that information with the mediator, because it may be that the mediator can don his own armour and act as the messenger passing offers in that case, whereas without that information, the mediator might have gone on very willingly with one party who wanted to present it personally, without realizing that that would be an exacerbation of a previous adversarial atmosphere between the parties. I've even had mediations where I've not been told there's been a previous failed joint settlement meeting or failed joint mediation. So information that you provide to the mediator in the confidential surrounds of the pre-mediation call and the mediation itself is absolutely vital to enable us to do our job to the best we can to help you.
Thanks, Paul. Also, another role that we play a part, a really significant role, is when there's an impasse and when the negotiations have faltered. I'm not going to go into that right now, because it's a whole other subject and we're running out of time. But hopefully at some point we'll reach a part and the stage where the parties agree on a figure. The next step then is to have that written down, Tomlin order, whatever form compromise agreement we need, have that signed off, and then you have a resolution and an end to your claim. If you don't reach that point and the parties are still at some distance apart, I tend to ask the parties to leave their last offers open. I keep in touch with the parties after the mediation to see if there's anything further we can assist with. And as we know from our experience, matters do resolve 2, 3, maybe 4 weeks afterwards. So we do keep in touch with the parties on that. So hopefully that gives you a good overview of what a typical mediation looks like. We've got a few minutes left, so we'll just have a quick look at some of the ways we can make that a success. Paul, we amongst ourselves talk about getting clients on board, defendants and claimant clients on board. What for our audience do we mean when we talk about that?
Well, when acting for the claimant, what I mean to say is make sure the claimant fully understands what this process is and what's going to be involved. We do, as Phil said, offer claimants in particular, but anybody who's not been to a mediation before, the opportunity of meeting us beforehand. Do encourage them to take that up. We'll talk them through the process, introduce ourselves, and show them if it's on Zoom, how the Zoom works, and so on. Also, explain about the negotiating process. The number of times I have a claimant who says to me, but I've already given up £1 million. So explain the difference between your approach to resolution compared to, for example, the schedule of loss that you've served and got your client to sign and served on the defendants in the adversarial process. The client may have set his store at that bottom line figure, and anything below that is seen to be giving away. If you properly prime the client as to why you created the schedule in that way, and then what the likely brackets of resolution are likely to be and the process of getting there, the client will buy into that. On the defendant side, remember that in mediation, information emerges as absolutely vital. I would like defendants to make sure that the right people are there in the right mood to adapt to circumstances. So if you need authority, there's a person there with authority or easy access to authority. And associated with that, remember that it's the individual client's case, whether it's claimant or defendant, not the lawyer's case. And there are cases that I've mediated where it's absolutely glaringly obvious to an independent observer that some of the lawyers involved have a greater investment personally in the advice they've given than if they'd realized what it's looking like from the outside, stepped back as a neutral and actually reflected the discussion that had been held during the course of the mediation. So very important to get the buy-in from the claimant in particular.
I often hear, and I'm sure you do, Paul and Phil, that I often hear, right, because I ask at the start, what do you want to the claimant? And I so often hear, well, I want a resolution. This has been going on for years and years and years. I sometimes feel, and it's not for me to be judgmental, it's me to help the parties, but I sometimes feel that the client really sometimes isn't given a sufficient opportunity to say what they would like. In other words, and whilst we would all respect the lawyers, as I say, who by and large much cleverer than me. If that's their advice to the client, we wouldn't dream of interfering with that. But turning to the client to say, well, what do you want to do? This is as far as they seem to be able to go. What do you want? Sometimes that's left to the mediator to do. And just following up Paul's point, it is the client's case, and I think it's worth bearing that in mind.
Thanks, Brian. We're running out of time. Probably, I see. Just a reminder that we will send out contact people who registered and send out the paper on position statements. And if you've any questions, please fire them in now on the Q&A question, or send them to us later. And at any time in the future, if you're questioned about a mediation or cases it's suitable, give us a call. We're more than happy to answer any of your questions. With the last couple of minutes, I'll just pick up one of the things I was going to talk about, and it's just to, if you do go to a mediation, I do encourage you to allow the mediator into your discussions and deliberations, and take them into your confidence. Often, back when I started mediating, I'd perhaps go into a room with an offer and they'd say thanks and ask me to leave. And anybody who's done a mediation with me now will know that I will tend to say, do you mind if I just sit in the corner and listen while you talk about this, and you kick me out at any point you like? And why am I doing that? Because I can learn an awful lot that can help you. Okay. And that's what I'm there for. Hopefully I'm going to add some value to this process. So I need to help you, and by allowing me involve me in your discussions, you can help me help you. So I do encourage that. And often I know the inclination is to just ask me to leave while you chat privately. And of course, I'll give you every opportunity to do that. But it is really helpful to allow the mediator into your discussions and deliberations.
It also reduces the need for playing devil's advocate, doesn't it? Because parties are miles apart. You're saying, so have you thought of this? And I'm always very conscious that these guys are thinking, Brian, if you could think of it, then in half an hour. But of course I have, and this, but you don't have to do if you're sitting and listening to the what's actually being said to the client on both sides.
Thanks, Brian. Brian, Paul, any last comment before we sign off?
Good luck to anybody now embarking on their first mediation. I'm here waiting to receive your inquiry.
I should say, yeah, and if you've got somebody from the firm who's already done a mediation, ask them to sit in. I know, it's billable hours and everything. I know that it's not easier said than done, but if you have a doubt, then maybe that's a way. Or sit in on one of
that instead of counsel.
Yeah,
I've certainly had that conversation with people who said, "Oh,
the way you were talking about
because I've not done a mediation before." Well, has someone in your firm done it? Why don't you do that?
Yeah,
oh, that's a good idea.
Yeah, exactly. Okay, I think we're done then. Thank you all very much indeed for joining us, and we do hope to see you again. We have another webinar on the, I think, 11th of September. We'll give you a summer break, and we'll be back in touch then. Thank you all very much indeed.